Thank you everyone for joining us. Thank you for those of us joining on Facebook Live. You can see down in the chat on the bottom of your screen, someone just jumped in, Megan just jumped in from Comox territory. And if you're comfortable, just say where you're joining from and what territory you're calling in from, if you know. For those of you who don't know me, my name's Torrance. I'm the campaign director at the Wilderness Committee. We're extremely grateful that you can join us for this update tonight. It's very hot out in most parts of where I think folks are calling in from. I hope that you are staying cool wherever you are, and that you can have a good update from us tonight, and then a good evening wherever else you are. I myself am calling in from Cowichan territory, from my home here in Cowichan territory, so-called Duncan, BC. And wherever you're calling in from, you're calling in from the territory of a nation, and recognizing that and sort of thinking about our responsibilities and how we can honor that and be respectful of that is really what tonight is all about. As I mentioned earlier, I work for the Wilderness Committee, and we're honored to help support the Nuchatlaht Nation in their work to get their territory back and to take care of it better. The Nuchatlaht are currently pursuing a title case in the Supreme Court of BC that's about halfway through, and we're lucky tonight to be joined for an update by some leadership from the Nuchatlaht community, as well as the lead lawyer on the case. Tonight, we will hear from each of those three speakers briefly, and then we will have some time for a Q&A afterwards. There's a Q&A function down at the bottom. You should be able to see it if you click on More and then click Q&A, and you should be able to type your question in there, and we'll get through as many of those as we can. If there's not a lot, we could wrap up before 7. Again, it's hot, but we have till 7 if we need it tonight. So again, thank you so much for coming, and I will pass it over briefly to the House Speaker for Nuchatlaht. But first, I will introduce the Ta'ihatwe, the head chief of the nation. Klakwiskum, or Jordan Michael, is here joining us, as well as House Speaker Hishamanouth, or Archie Little. I'll introduce Archie first to open us up here this evening.
Thank you, Torrance. We'll start out by asking for a little guidance of strength, of knowledge, of wisdom and strength. And we thank the Creator for today. We ask Him to guide us, to give us the strength and the wisdom and the knowledge to make better decisions, to always look after everyone. That Nuchatlaht has a history of being so generous, offering help to anyone that came to our community. And as we fight to be recognized as people that can own, that can manage, that can enhance, that can protect, that can access and share all resources. And we ask the Creator to help people to understand that. And I just want to say that I speak on behalf of Tlakaskum, the copper maker, Ta'ihatwe with Nuchatlaht. Just a few words that to open that, it's time we looked at how the First Nations lived for thousands and thousands and thousands of years, and were very successful, where we had no homelessness, we had no sicknesses, and we had we were healthy, well-organized people. And I think it's time we looked at that. We get judged by people that have been here for about 160, 170 years, and that hasn't worked for First Nations peoples. We need to be close to the land. We need to be close to the ocean. We need to be close to people. And so, and I just want to honor the Chilcotin for the work that they did before us. And I know that they will do well, that they will do better. but on behalf of Nuchatlaht, with the loss of the things that we've lost through the residential school process, through the acts the government has passed to keep us off the ocean, to keep us off the land. That we thank our ancestors for what they've given us, and in our culture, our ladies are the strength, our ladies are the brains, our ladies are the thinkers, and so I thank Quaitna, I thank Anat, I thank Queen, I thank my mother. My mother was a lady that never touched alcohol. She never had a drop of alcohol in her life. And I was brainwashed in Christian Indian residential school that she was a raging alcoholic. That's what they taught me. And just to remember those things, that that we the work that we do it in the honor of our women, because they're such a powerful being. There are grandmothers, there are mothers, there are aunts, there are sisters, our cousins, that they're the strength of our community, and that we work towards waking up again. What this case has done for Nuchatlaht. We're going to grow, we're going to get healthy, we're going to get stronger even, because we'll be good helping other nations. And so, just to remember that we thank Jack for asking us to go to court, because of Jordan Kakoskum and his family, for being our Tyee, for agreeing to take on this massive, massive challenge. And as Nuchatlaht, we have no fear of going to the front line, and we've proven that. And so, to remain focused, we have a lot of work to do, and we don't fear work. But we as a Nuchatlaht, we want everyone to benefit. We want, our wealth was abundance, and we need to get back to that. Where the people of the herring were in my time, Nuchatlaht had herring spawn from Steamer Point all the way into Mary Basin. That's a long way. And by the time we fought to control herring, to manage the access, there was only herring left in Rosa Harbor and Nuchatlaht. That's how small it was. Before, we had to fight to stop it. And I think that, we all need to think about coming to the table to make decisions together, so everyone benefits. And so we welcome our Tyee. I'm sure he's tired just coming out of camp, but we'll see him soon. Chu, I hope we have a good discussion, lots of questions. If we can't find the answer, we will find the answer somehow. Thank you.
Thank you so much, Archie. I'll pass it now to Jack Woodward, a lawyer who's been fighting in court for Indigenous rights for a long, long time. I don't want to say how long, Jack, but I'll pass it over to you now for an update on this case and sort of where things are at, how it's been going, and what's coming up in the months ahead.
Thanks, thanks, Torrance, and thanks everybody for joining. It's been a very exciting time. We had a 40-day trial this spring. It began in March. It ended at the end of May. It ended quite dramatically with the last bit of cross-examination of the Crown witness that involved a particular point that actually was fun. Now, you wouldn't think a 40-day trial would be fun, and it's true, we were completely exhausted by the end. But at the very end, there was cross-examination about a particular word that one of the elders that Archie was just referring to, whose nickname is Girl Nan. Her name was Lillian Michael. She was born in 1900, and she was interviewed in 1970 by an anthropologist from the Provincial Museum, and there's tapes of that. So the province's anthropologist in this case listened to one of those tapes and thought that what she was saying was 1898, that this group called the Shumat hadn't even joined the Nuchatlaht until 1898. And that would leave a big hole in the donut. It would mean that Nuchatlaht territory was what we were claiming, but there would be a big area right in the middle, right at the head of Mary Basin, that wouldn't have been part of the claim. So of course we were trying to defeat that aspect of the province's defense. And it turned out through quite a complicated series of questions and answers that she was not saying 1898. The interview was conducted entirely in her own language. She was saying a word that sounded a bit like 98. It was Naiye. And Naiye means echo in the Nuchatlaht language. And echo was the nickname of Oscar Dean's uncle. So this is all too complicated for a seminar like this, but the cross-examination involved a long series of questions and answers, and my staff put those questions and answers on a coffee mug. You probably can't see it, but this is my favorite coffee mug now because it has the Nuchatlaht words that on it that remind me of how much fun the last day of the trial was. So anyway, we ended the trial with the judge saying that we're to go away and write our arguments in writing, which we're doing right now. We're doing written argument. Our deadline is next Tuesday. So much for the long weekend. We're at our desks all weekend putting the final touches on our written argument. It's about 300 pages long right now. It'll be a little longer by the time we polish it up and have it ready, but I'm quite proud of it. It is a pretty definitive answer as to why the Nuchatlaht will win this case. Now, then what happens at that point is the province writes their written argument in response. We'll have an opportunity to write a brief reply, and then there will be 3 weeks of oral argument scheduled. So that starts on September 26th, Monday, September 26th. That's in the courthouse in Vancouver. It's public, and you're all welcome to come. We'll speak for the first week. That's me. I'll be on my feet talking for a week starting on September 26th, basically going through the points in the written argument. And then on October 3rd, Monday, October 3rd is the beginning of the Crown. That's the province of British Columbia's opportunity to respond. And there'll be a brief opportunity for Canada to respond also. They're a party. And then the next week, the Monday is Thanksgiving, the October 10th. And there'll be we must end by October 14th. The judge has said that's his absolute last day for this. So on there may be some argument on the 11th, 12th, 13th, and 14th, and then it will wrap up. And then the judge will reserve decision. And at some point, we'll get a decision. It'll be probably close to the end of this calendar year, or maybe in early 2023. This judge is famous for writing his decisions quickly. He's very hardworking, so we expect that he's made all his notes and is ready to hear the final argument and finalize how he's going to decide the case. What we're seeking is a declaration of Aboriginal title. Really, this is only the second time in British Columbia history that there will have been a case that goes to conclusion. Third time in Canada. The very first case was in 1979, the Baker Lake case in the Northwest Territories, where Justice Muldoon of the federal court held that the Inuit people of the Northwest Territories, this before Nunavut was formed, had Aboriginal title. That was a successful claim of Aboriginal title. And then there was the Chilcotin decision, trial in front of Justice Vickers that ended in 2007 and went to the Supreme Court of Canada. And in 2014, the Supreme Court of Canada declared that the Chilcotin had Aboriginal title to about 2,000 square kilometers in the central interior of British Columbia. And tiny Nuchatlaht is going to be number 2 in British Columbia, number 3 in Canada, because there are no other cases that will finish their trial and get to decision that quickly. The feature of the Nuchatlaht case has been that we've avoided all conflicts with neighboring tribes. We've been very careful not to overreach not to get involved in overlaps. There are overlaps. There's significant overlaps. There's areas where the neighboring First Nations make claims on Nuchatlaht territory, both north and south and east, and it took restraint for the Nuchatlaht to decide that they were going to go for what they could claim in this case, in this first case, without engaging any kind of a fight with their neighbors. That was under the leadership, when this case started, of Chief Walter Michael, and now deceased, the late Walter Michael. That's Jordan's father. Our anthropologist in this case, John Dewhurst, knew Walter Michael and knew his father, who was Alban Michael, and he was the chief before him. John Dewhurst also knew Alban's father, who was Felix Michael. Felix Michael would be Chief Jordan's great-grandfather. John Dewhurst knew him and knew his wife, Lillian Michael, the same woman that I was just talking about, who did not say 98. She said Naie, which is the nickname of Oscar Dean's uncle. That would be way too complicated for me to explain the significance of that, but I can tell you it was really fun to end the trial on a high note like that, to be able to extract from this witness this evidence that completely overturned the theory of the Crown up to that point. So the theory of the Crown. So you'd think that this case should be simple. Well, it's everybody knows these notorious facts, that the Nuchatlaht have always been there. They've always occupied that land. That there's really on the surface of it, there should not be any huge resistance from the Crown, because everybody knows that they were there, that they occupied the land the way their forefathers and ancestors always had. And so what's the dispute about? What is it really about? So what an interesting thing happened right in the middle of the trial. You'll recall that British Columbia enacted a law to implement the United Nations Declaration about 2.5 years ago. And when they did that, one of the promises that they made was that they were going to change the instructions given to the Crown lawyers who do civil litigation involving Indigenous people. And those instructions came out while we were in the middle of the trial. On April 21st, they came out. And so we were very excited by this, because we thought, oh, they're going to drop all those silly defenses and we're going to actually have an easier time of it. So I'm going to tell you how that turned out in a little bit of detail, so you understand where we're at. Now, the Attorney General at that time was David Eby. David Eby has just retired from being Attorney General because he's running to be the leader of the NDP, and you can't be a leadership candidate and hold a cabinet position. So just to bring you right up to date, he's no longer the Attorney General. His portfolio as Attorney General has been handed over to Murray Rankin. Murray Rankin is the Minister of Reconciliation. He's now also the Attorney General. So that just happened last week. And so I don't know if circumstances might still change between now and the date of oral argument. This is a very fluid matter, and it's open to the government to make changes as they go along. So I know that Torrance began by saying, well, maybe you would like to assist the Nuchatlaht. And what I'm going to suggest is some ways that you might assist the new minister, Murray Rankin, to do the right thing. And I'm going to go through 7 points. These were what I called the Attorney General's the seven deadly sins. These were the problems in the province's position that they used to take. And what I was watching for on April 25th is to see if they would fix those 7 deadly sins. So here's what they were. I'll tell you what they were and what happened to them. First of all, the province used to argue that Aboriginal title has been extinguished. that the Nuchatlaht's Aboriginal title was extinguished. Now, they didn't use the word extinguished because that's not politically correct. They used the word displaced, but it's the same thing. And I should tell you that this was a success. On April 21st, that was dropped. The province is no longer arguing extinguishment in this case. So I give them credit for that. That is a step forward. That's one of the 7 deadly sins was exonerated, and they're no longer doing that. They're no longer arguing displacement. A second of the 7 deadly sins was to argue that the Nuchatlaht had abandoned their lands. And again, on April 21st, the province dropped that pleading. They're no longer arguing abandonment. Now, that is to their credit. So those are 2 things that were changed in a positive way as a result of the province adopting the minister's new directive. Now, there's still 5 more sins. One of the things that the Attorney General argued was that the Nuchatlaht lost their connection to the land. And they did not change that on April 21st. They're still arguing that. They say that the Nuchatlaht they're not living there, and they don't have a strong connection to the land. Well, of course they're not living there. It's illegal for them to live there. The province claims that land as Crown land, and under the Forest Act, you're not allowed to cut down a tree and build a house out of it, even though we're arguing that land belongs to the Nuchatlaht, and when we win, it will belong to the Nuchatlaht. And then, of course, they can cut down a tree and build a house out of it. They can do what they want. It's their land. But right now, the province says it's illegal. It's just as illegal for Chief Jordan Michael to cut down a tree as it is for any non-Indigenous person. Nobody can go into that forest and cut down a tree, and you can't live there. You can't even pitch a tent there. It's not a park. You can't do anything there. And that has not changed. The province is still arguing that the Nuchatlaht lost that connection to the land. Now, that's not to their credit. That's a problem. The province must continue to make bits of progress in this and stop raising these obnoxious defenses. The 4th deadly sin was that the province is arguing about the date of sovereignty. Now, this sounds like a really obscure issue, but the point about Aboriginal title is that Aboriginal title is a melding of the Indigenous legal system and the Canadian legal system. You take the ownership that the Indigenous people had at the time that Canada became a country, and you enforce that through the Canadian courts. That's what Aboriginal title is. You convert an unenforceable right into an enforceable right. You take the ownership that the Aboriginal ownership that was in place before the date of British or Canadian sovereignty, and upon sovereignty, a new court system kicks into place. Namely, what we have is called the British Columbia Supreme Court. That court system kicks into place, and then the old rights that were not really recognized at common law become recognized at the common law and enforceable in the Supreme Court. So that's what Aboriginal title is. And that's the significance of the date of sovereignty, is that the date of sovereignty is the date when those rights became meaningful in the British Canadian legal system. So it matters. Now, in the earlier that date is, the more difficult it is to prove, because there's less and less written records. There's less and less ability to prove a right the earlier it is in time. So in this case, in the Nuchatlaht case, the province persists in arguing that the date of sovereignty is 1790, which it's virtually impossible to prove at 1790. Now, it's a ludicrous argument. All of the court, the Supreme Court of Canada has on 3 occasions said that the date of sovereignty in British Columbia is 1846. It's crystal clear that that is the date. It's even written into provincial statute law, and yet the lawyers are standing up in court saying it's 1790. We still have evidence that we would win if it was 1790, but it's much more difficult. It has to be 1846. It's the only logical and sensible date. So that didn't change on April 21st. the directive issued by the Attorney General in 1846 was not sufficiently potent enough to cause the province to change that one obscure point in their pleadings, and we're still having to argue it. I should say even the judge looked very skeptical about the date 1790. He said, he actually said to the lawyer, "Are you still arguing that point?" And the provincial lawyer had to say, "Yes, we're still arguing that point." It's really silly. But anyway, that's another one of the things that we're dealing with. That was the fourth deadly sin. The fifth deadly sin was a really obnoxious argument. The province used to argue that the Nuchatlaht were too small and weak to have Aboriginal title. Too small and weak. Now they did make one change. They dropped the word weak. They just now say too small. And then what they're saying about that is that the Nuchatlaht did not have the capacity to defend themselves. Well, there was some really fabulous evidence came out of the province's own witness. There was a story about this. What happened was in the 1830s, may have been 1820s. We're not sure of the date. There was a war, an intertribal conflict between the Ahousats and the Otsosats. Now the Otsosats don't exist anymore, probably because of this war. But the Ahousats were fighting for their lives. They're a great, big, powerful, strong band now. You'd never know. But back in 1820, the Ahousats were small and having a hard time because they were having this big war with the Otsosats, also in Clayoquot Sound. And who came to the Ahousats' rescue but the Nuchatlaht with 200 rifles? Now, in 1820, 200 rifles was an enormous armament. I was like, this was incredible. And the province's own witness even said she was astonished that they had 200 rifles in 1820. I mean, that would be a lot of rifles today, but in 1820, that was really a big. So anyway, obviously the Nuchatlaht had the capacity to defend themselves in the relevant date, which is 1846, because if they could provide 200 rifles to their relatives, the Ahousats, 20 years before that, they were a powerful tribe. So that was a highlight of the case, actually, to disclose that fact and to put to bed forever this idea that the Nuchatlaht were too small and weak to have Aboriginal title. They certainly were not. Still, Archie has adopted the motto of tiny but mighty, which I think is totally appropriate. Tiny but yeah, mighty. And there was other evidence too about the diplomatic capacity of the Nuchatlaht. This is a very interesting point. The Nuchatlaht is small in territory, kind of the way Luxembourg is small in territory in Europe, but Luxembourg exists, even though it's squished between France and Germany. And you'd think, well, how could it possibly exist between those huge powers, overrun over the years by Napoleon and by the Kaiser and by Hitler, and everybody overruns Luxembourg, but it still exists, still a country. How do you explain that? You can explain it because of exactly the same reasons that Nuchatlaht used in their history, which was intermarriage with high-ranking families in their neighboring tribes, and military diplomacy, diplomatic relations. It's the standard technique of international relations throughout the world, and Nuchatlaht used it brilliantly. And so, in addition to having 200 rifles, they were master diplomats, and so that's how they. And that's it. That's how they survive. So the province's argument of the Nuchatlaht being too small and weak, they dropped the weak part, but they're still too small. They're not going to get anywhere with that. And so, but that's something that they should not argue. It's the bully's argument to say, oh, you're too small to have Aboriginal title. Only the big should have rights. The small don't have rights. No, we don't believe that in this country. We don't believe that. In fact, Canada is built on the proposition that you don't have to be big to have rights. That you can be small and have rights, so that's true of Indigenous people as a whole, who are a minority in this country, but they still have rights and they still should be defended. But that also applies to a small group like the Nuchatlaht, that they have rights. So that's an obnoxious pleading by the province. One of their sins, one of their 7 deadly sins that they did not fix on April 21st and could still be fixed. I'll go through them a little more. The number 6 is this stirring up trouble with neighboring First Nations. So we complained that the province should stop raising as a defense the idea that neighboring First Nations might be claiming part of Nuchatlaht territory. People are entitled to advance their positions, but the province should not take advantage of that to the province's own benefit. Relations between First Nations is complicated enough rather than the province jumping in and saying, oh, look, this First Nation is fighting with that First Nation, therefore neither of them should have anything. That's what the province is doing. It's worked in the past for the province. It has been a successful strategy for the province, but it's obnoxious and it should not be used. And it's still being used in this case. They're still arguing that the Nuchatlaht should not have their title because there's ongoing, I should say, petty disagreements about boundaries with their neighboring First Nations. The province says, oh, look, it's not 100% settled, therefore we can't do anything. Now, both the neighboring First Nations have explicitly said they do not object to this court case. They don't object to the Nuchatlaht getting their relief, and they're not going to intervene. So it's really an imaginary worry that the province is trying to put in front of the judge, and it's obnoxious and they shouldn't be doing it. The 7th of the 7 deadly sins is that the province is still arguing that if the Nuchatlaht lose, the province wants costs against them. Legal costs, court costs against them. Now, that one was really silly because first of all, the Nuchatlaht are not going to lose, but it's an unpleasant threat for the province to be saying to a First Nation, if you stand up and ask for your rights and you lose, we want you to pay they want the First Nation to pay the province's court costs. The only way that a First Nation can establish their rights, the only legitimate way that you can establish your rights in this country at this time is through court. All of the other processes have failed. I've been doing this for 43 years. All of the other processes don't work, and going to court does work. And so that's what the First Nations are faced with. And it's difficult and expensive enough to go to court that First Nations should not be discouraged by the threat that there will be costs awarded against them. Now, the Nuchatlaht are completely fearless about this. They don't care because first of all, they know they're going to win. And secondly, they would just thumb their nose at an order that they have to pay costs to the province. They're not going to pay costs to the province. That's ludicrous. But it's in there in the pleadings and it shouldn't be. The province should never do that. They should never say, if you sue us for your Aboriginal title and lose. Now, there might be First Nations who might lose, right? They might advance a claim. They might overreach, or they might have a defect in their pleadings. You know, you can imagine that not every case is a winner. And it's not pleasant that the province is saying in every case across the board, they say, oh, if you lose, we want costs. That's not right. So, so that's the 7 deadly sins. That's what happened on April 25th. The province's scorecard, they get 2 out of 7. That's not good enough. What about the other 5? And so there's still work to be done. There's still letters that could be written to the new Attorney General, Murray Rankin, who's a very fine guy and has ears and will listen. So I recommend, if you want, I can help people with that letter through the really, really helpful work the Wilderness Committee and Sierra Club are providing to back this case up. So they have wonderful letter writing tools and it's very helpful. So if people want to be politically engaged and give Murray Rankin some guidance, I think that would be a good thing to do. The province, as I say, is going to be spending starting Tuesday next week, when we hand in our written argument. That's when the province will be writing their argument for the next 6 weeks. So there's time right now to tell them what they should be writing down. Because really what this should be is the province should be neutral about this. Nuchatlaht people are citizens of the province. They have rights that are in the Constitution. There are they're the original citizens, and they're still there, and they have rights, and the province shouldn't be fighting them. The province should be at least being neutral. Now, Canada is also a defendant in this case, and Canada is doing more or less what I'm saying the province should do. They're saying, we're neither agreeing nor disagreeing, you've got to prove it. Well, it's easy to prove. So I don't mind that. That's fine. That's the proper role for the Crown to say, if you say you've got rights, prove it. We can do that. Not a problem. It's the resistance that we disagree with. So there's a little update to where we are now. There's a question here in the chat that I'll pick up with right now. The new directive was published on April 21st. No, that what happened was the timing is a little trickier than that. What happened was that just before that, earlier in April, the province filed amended pleadings, and it was in those amended pleadings that they had already fixed the first two, so that the other 5 were still in the pleadings. So what I did on April 21st is I put the new directive in front of the judge. This was another sort of fun moment in the trial. You got to forgive me. I mean, lawyers, we've got a pretty boring life sitting at our computers typing stuff. So this kind of thing we think is fun. I put the new minister's directive in front of the judge and said, look, there's this big change has to happen. It's a serious, sober change issued by the minister. I think this lawyer beside me, the government's lawyer, is going to need some time to amend his pleadings. The judge said, yeah, this is serious. Yeah, he looked at the judge. He looked at the lawyer beside me, the province's lawyer, and said, I guess you're going to need some time. And he immediately stood up and said, no, we've already made all the changes we're going to make. So you see, they'd fixed 2 of the 7 deadly sins a few days earlier, so that when it came down, they were not going to change a thing. So they still have some work to do. But that's a great question. Thanks for asking about the timing.
Archie, I see you've got your hand raised there. Did you want to jump in? You're on mute.
If Jack doesn't mind.
I'll shut up.
No, Jack, no. I just want people to understand with Nuchatlaht, we're in a hereditary system. We've had the same pay from the same family through Felix Michael, Alban Michael, Walter Michael, Jordan Michael, Eric Michael, the future, and Manson Michael. And so, we know who our Hotway are. And I just want to say that our tie with late Felix Michael was well respected by the other Hotway in the Nuchatlaht land. When there was a potlatch, a Hotway wanted to throw a potlatch, they had to ask Felix Michael's permission. To me, that's respect. And people didn't go to war with people they respected. And as Jack said, our Hotway married Hakum, the queens of other nations, and that's how the Hotway are connected. And it's important to know that those pre-married, those what do you call them? Pre-arranged marriage. They were there for a purpose. But to understand, Felix Michael, we have an IR on Nootka Island. Felix allowed people traveling up and down the coast. He offered that IR as a resting place. That's important. And our neighboring First Nation was having problems with one of their Hotway. Felix allowed them to stay at Upnit until they fixed what was wrong in their nation, and then they went home. But to understand Nuchatlaht, you heard me speak of the wealth of Kakoskam's Hahofi, the wealth of it. It was shared by many non-Aboriginals. We had big trolling fleets that came into the Chatlets. And sometimes they needed poles. And sometimes they broke a pole because their poles were made of cedar. They'd go to Felix Michael, non-Aboriginals, and request that they go access a pole, a tree to make a pole. I've seen that. And I've seen the First Nations knowing where the boundaries are. They're fishing, they're catching fish. They've entered Felix Michael's hahoti. He deserves to be paid. And I've seen them as a young boy, fish being brought up to Felix Michael's home because he owned that hahoti. So, it's, and, we did not have to go to war at times because we're respecting each other very much so. And to understand though, them boundaries were fiercely protected. People just didn't come and go as they pleased. There were lookouts. And so, we thank our ancestors for leaving what they've given us. It's made Nuchatlaht very strong. We're very proud. We're small, but we're strong, we're powerful. Thank you.
Can I just comment on two aspects of the evidence that relate to what Archie just said? The first one is he used the word takasan, which is that name. That in the Nuchatlaht tradition, a name is property, and a chief can be awarded a name at a potlatch. Those names are you don't just get any name. You have to have the right to have that name, and it has to be awarded at a potlatch. So we showed that name, which is spelt differently by English speakers who hear it differently, it's sometimes recorded as Terasom, sometimes as Teesom, sometimes the way Archie just pronounced it. For 232 years, we've got an unbroken record of that name. That was in evidence in front of the judge as the senior chief of the Nuchatlaht. Second thing, though, is a point about pride in the accomplishments of ancestors, which is something that I think is often overlooked. In the majority culture, people can say, "Wow, it was my ancestors who built, if you're Greek, the Acropolis, or if you're French, the Eiffel Tower, or whatever." People can look at the accomplishments that their grandparents and further back and that things. They look at those things because they might be books that were written, or they might be architecture that was built, or boats that were built, or whatever. It's different for the Nuchatlaht people because they lived fairly light on the land, and they didn't have a literate culture, so they don't have books. So what they have is a very fragile physical record, which is the archaeological record of occupation, which is demonstrated in the culturally modified trees. And one of the really fabulous parts of the evidence that was put forward in this case is this decade after decade after decade that the Nuchatlaht people harvested and managed the great cedar forests. So one of the things that Archie just emphasized is the hereditary succession of chiefs. It came out at trial, one of the really important reasons for that, or explanations for why that's important, because the cedar trees were used in two main ways. They were used in multiple ways, but two main ways. One of the ways was to create cedar bark. Cedar bark was used for a great number of purposes, but you would recognize the woven cedar hats and cedar clothing and cedar rope. Multiple different ways that cedar was used. Now that's from one kind of that's from cedar trees where you can strip the bark from the bottom up. You can strip a tapered bark strip off a tree. Once you've done that, that tree is not useful for monumental cedar like canoes and house posts and planks for building the big monumental architecture for which all the West Coast cultures are famed. So you had to have a preserve of the trees that would be kept for not just 20 years, but for hundreds of years, so that those trees were protected from bark stripping, because it's too easy to come along and just strip a bark off it, and then you can't ever use it for a canoe. So this evidence came out. Well, how did Nuchatlaht culture, and Nuchatlats in particular, how did they organize themselves to make sure that there was always going to be a reserve of the giant cedars that hadn't been bark stripped, so they were available for building canoes? Because they're in short supply. And the answer that came out in evidence is that was one of the beauties of this unbroken hereditary continuity, is because the chiefs would pass on to the next chiefs, to the next chiefs. Don't bark strip in that area. Those trees are being saved for canoes and houseposts and other monumental uses. So it's an actual indication of not, it's not as though the hereditary chief system is just selfishness. It's actually necessary in order to preserve this fundamental basis of the economy. It was great evidence. This is the first time that's ever come out in court. So that was a vindication of what Archie was just telling you. Thank you. That's the two things that I wanted to say.
Just one final point there. When Hakum married into another nation, another Hatwit, she was given songs, dances, and the right to access resources. And so the bond keeps getting stronger and stronger. You know, and the lady could share, you know, the history where she came from, and you know why they were married. It was very strict, like the old buffalo used to tell us, if a Tyee married a commoner, he came down in stature. And so, you know, they were always held very high. Thank you.
I'll answer a question that came up about the name Tarasom.
We're gonna jump to Q&A quickly. I wanted to introduce the Tyee first for a few words from him, and then we'll move into to questions. In the meantime, there's a question and answer box at the bottom for folks listening. I can see there's at least 3 questions in there already. If you can drop those in, if you have some more for the speakers, you can put those in there now. But before we get to question and answers, I'll introduce Klakwishkum, Tyee Hatwe, Jordan Michael to share a few words. Are you there, Jordan?
Hey, Torrance. Hopefully you guys can hear me.
Welcome, Jordan.
Yeah. Hey, thank you. Hey, I just want to thank everybody for their opening remarks, and obviously thank everybody for joining us to see where we're at in this historic case in BC. We appreciate the support. Yeah, and I apologize. I only have access to cell phone, and just got off work and trying to log in and make it work. So, but again, thank you everybody for being here. Glecko.
Woo.
Thank you, Jordan. I'll pass it over to my colleague M. You can see the two tree logos there. That's M and Alex, who helped organize this webinar and are keeping things going on the technical side this evening. So M, I'll pass it over to you for a few minutes of question and answer.
Okay, thanks, Torrance. I have a few questions so far here in the Q&A section. I'll just start at the beginning. Looks like it's for Jack. Will oral arguments be a rehash of the written arguments, or will this be a chance for respondents to make new arguments? I'm not sure if you answered that already.
There won't be much. It'll be an elaboration, but not new art. There won't be new arguments. No, they won't be able to make new arguments.
Perfect. Thanks, Jack. Next one from Megan says, it's mind-boggling that the province argues a loss of connection to the land when that connection was forcibly severed by the government. How can they argue that without acknowledging that the land was forcibly taken from the people?
Well, you make the point. That's what we're going to be saying. Good point.
Great. And then another question from Megan is, does the Beaver Lake Cree funding decision have any impact on the case?
So the Beaver Lake Cree funding decision, I'll give you that's an example of how things can get very expensive. I started that case back in about 2005 or 2007. I'm not the lawyer on it anymore. Another lawyer is doing it. It was called Lame Man, or Ron Lame Man was the chief. The new chief's name is Anderson. And so it went to the Supreme Court of Canada, and the decision came down just on March 19th, saying that the impediments to funding orders are going to be thrown aside, that there's going to be a lot more accessibility for First Nations that need government funding to advance their case. It's too late for us, but it's not too late for the next case.
Perfect, thank you. And maybe this is a question for everyone. How can everyone support Nuchatlaht? You mentioned, Jack, writing a letter to now Murray Rankin, which we put a link to our take action in the chat, so everyone should see that. Any other ways that folks can support Nuchatlaht? Okay, I can answer one of those things. There is a Chaft page, a fundraising page. So if people want to support financially, we have set that up, and I will put that link in the chat right now.
Mhm.
Not everybody can attend court on September 26th, but that certainly is a good thing to do. I don't think we've organized anything yet, but I know that when the trial itself began back in March, there was a rally on the courthouse steps.
Mhm.
I imagine that Jordan and Archie are going to want to have some kind of a presence when we go to start the oral argument on September 26th in Vancouver. So that's another way to support. It seems to me that it's Murray Rankin, our new Attorney General. I'm an optimist. I'm always optimistic. So I mean, I think he'll be an improvement over David Eby. David Eby, he had two portfolios. He was both Attorney General and responsible for housing. He did a good job on housing, but he kind of didn't pay as much attention, certainly, to the Aboriginal side of his portfolio. So Murray Rankin, I'm sure, is much more committed to solving the problems. So I know writing a letter sounds kind of dry, but I'd be happy to work through Jordan and Archie and the leadership, and also through Emily and Torrance on this call, and Alex, to help people craft the language that they could send to Murray Rankin, because he's a thoughtful guy, and if you say the right things, he'll hear you. And it's still the case that there's nothing more powerful than a letter to a politician. They get letters. I mean, it's way better than like social media or any of that stuff. A letter, even an email, has some impact, and especially if it's worded nicely and it makes a clear point.
Mhm.
Some of the points that are people making in this chat right now, and one of the points that was just made in the Q&A, Megan's point. I mean, you're right. I mean, that's a very good point that she made about the forcible taking of lands, and how can they say, well, you've lost your connection, when it was. Make that exact point in an email to Murray Rankin and say, you shouldn't be arguing that. He'll hear you. So that's I'm just suggesting that's a way to be heard and to help Nuchatlaht.
Mhm.
Go ahead, Archie.
Thank you. Just I have a question, but one thing people need to understand, I think, that the Nuchatlaht um, taken away from our land. We were in residential school for 10 months of the year. And we did not get home till July and August. So we were gone. And then the wealth of our Thais, Hahosi, they chased us off the ocean that we had to go we had to move on just to make a living. We could not benefit from the wealth of Jordan's Hahosi, because of licenses, because of quotas and all that. But I think that with this court case, we're going to return to the land, and we're going to start healing. And to me, that's very important. That one day the Nuchatlaht will all be home, we'll all be healthy, we'll all be working, and we'll all be Nuchatlaht again, and we'll return to our culture, and to understand culture is not just singing and dancing. Culture is everyday living, where we're teaching our children how to be good people, to be strong, to be proud of who they are, and we'll get back to our culture. We'll get back to our language. We'll get back to our history, because now we have that opportunity.
Can I add two things about culture that came out in evidence? First thing, there is the well-known Whalers Shrine that used to be at Nuchatlaht on Friendly Cove on the south end of Nootka Island in Moachat territory, and that there's photographs of it. It is absolutely haunting, spiritually haunting, because it was a shrine to the whalers who lost their lives out at sea. It got packed up and taken and put in a museum in New York, and it's still there, but it's not in Nuchatlaht's territory. What came out in evidence is that there was a whaler's shrine in Nuchatlaht territory. We didn't know that. It's amazing. Another one. So that's one spiritual connection. The other one, right at the very end of the trial, even after the thing about Naiye that I was telling you about on my coffee mug, was it's well known, these crystals that were found on the tops of mountains that were that had supernatural powers. They're called supernatural spiritual crystals. They're quite big. Like they're big. They're like this big. They're as big as a hot dog bun, and they're magic, right? They were in Nuchatlaht territory. There were these crystals. Unfortunately, they've been stolen, and there's one in the British Museum. So it's just like the Elgin marbles. The Greeks say, well, you should return the Elgin marbles to the Parthenon. The crystal from Nootka Island is in the British Museum. It belongs to Jordan. We'll get it back one of these days. But anyway, it was quite lovely evidence to hear about it and actually see a picture. There's a picture of the crystal that's in the British Museum is in evidence in this court case.
Jack, we can go tomorrow to get it.
I'm on the next plane. Let me finish this written argument first, and then we'll go.
Okay, it looks like I have one last question. It says, at what point will a case be taken to the ICJ? I assume that's the international courts, regarding Canada's genocide against First People. And will these title claim cases need to be litigated in Canadian courts before that's even a possibility? Jack, do you want to take that one?
I don't have an answer to it. That's I'm still in this case. It's
right. Okay, fair enough.
But the next question on the list is interesting. It's about damages. So this case is not about damages. And I'm not going to say anything about the next case because I want to get through this case first. But it's a very good question. That last question on the list, well, it's not the last now, but it says, after the Nuchatlaht wins back their land, can they sue for damages from industrial logging? The evidence that came out in court is that 80% of the magnificent ancient cedar forest that was in Nuchatlaht territory has been logged. The archaeological record is 80% of it has been destroyed. This is just a tragic loss. I mean, you know, I think how bad Chief Tahi Jordan must feel about the fact that his heritage, those trees, that magnificent forest, that beautiful place that his ancestors had, in the last 40 years, it wasn't logged early on. It was logged recently under our noses. And if we hadn't started this case, there'd be cut blocks going right now. It's an awful, and you can't fix that. That is a heartache that will be there forever, to see that beautiful land, those magnificent forests that your ancestors own, that somebody else has come and destroyed 80% of them. There's 20% left. That's what they're going to get back when they win the court case.
Thanks, Jack. I have one other question from Kathy. She says, where can I access the materials submitted to the court? She would love to read them.
Yes, once we file it, it's public. So as of Tuesday or Wednesday next week, they become a public document, and like everything in court is public. Figuring out how to get it is, I mean, there's no legal impediment. There's no issue about it. It's not private or anything like that. It's a public document. Courts are open in this country, but we'd have to figure out how to get your email address and send it to you and set up a system. We can do that through Sarah at the Nuchatlaht. We can do it through Emily, or we can do it through my office, and we'll figure something out. But yeah, hey, I'd love it if people wanted to read it. We're putting a lot of effort into writing it, so it'd be nice if somebody wants to look at it. It's good. Like I say, it's already 300 pages long.
300 pages, some light reading.
Oh, it's exciting stuff.
I see another question for clarification. Megan asked, Jack, did you say that logging has stopped in the territory since the court case started? That wasn't my under. Is that what you were saying?
There's no new cut blocks. There's no new cutting permits being issued. Yeah, that's right.
Right.
Not because we sought an injunction, but
Right.
because we could have sought an injunction. So the original notice of civil claim that starts the court case lays a foundation for seeking an injunction. So and of course the company and the province know that well. I mean, I did the injunction in the Mears Island case. We got that injunction in 1985. A lot of you weren't born then. We got an injunction to stop logging in 1985, and it still stands. You still can't cut down trees on Mears Island in violation of that injunction that we got from the BC Court of Appeal. But that starts with the same way that we started this case. You start with a notice of civil claim, and then you build the injunction on top of that.
Right.
We didn't need it now in this case.
Right. Archie, did you have something to add, or was your hand up from before?
Yeah, just, Jack, in our history, in our Nuchatlaht, in our recent history, we've had 2 whales. And the first whale was killed by the Nuchatlaht, and they towed it ashore, and they learned that they were on the boundary of Nuchatlaht. They towed the whale ashore, and they stopped, and Hotwood instructed one of the warriors to go get the Tahi from the Chatlets to take half the whale because they were on the boundary. And that's fact. And late Albert Michael was telling me that they found a whale that had died and it was fresh, and they towed it home. So we've had 2 whales that we know of.
Thanks. There's going to be lots of ways to take action. We have the letter writing tool that we posted. Em posted it in the chat a few times. I'm sure she can post it again just so it comes up. But that's it's updated after the court case, but it's not updated with the specific calls that we should be directing to Minister Rankin. You know, Jack needed a little break after the opening hearings, and then now he's writing the final arguments. But as soon as he's done, I think I heard you say next week we'll be bugging him for some updated language for this, so that we can make sure that we're getting, you know, focused, clear arguments to this minister and to the government about what they should be doing, what they should stop doing on this. So that will be up shortly. In the meantime, yeah, stay tuned. I know Murray Rankin has an office in Gordon Head. It'd be fun to do something there. Kind of welcome him in as Attorney General and tell him to do a better job than his predecessor. And like Jack mentioned, there will likely be some events, you know, in the lead up to the case or through the to the final arguments or through the fall, to stand with Nuchatlaht. So stay tuned for those. You know, follow the Wilderness Committee, Stand and Sierra Club are other organizations working to support the Nuchatlaht. And yeah, we'll stand together with this community, with this nation as best we can. I think that you know, we've worked through the bulk of the questions. It's a hot evening. I'm sure we've all got lots of places to go cool off. I'd like to pass it back to Archie, Tai, Jordan, if you have any last words, and Jack too. Archie, we'll go to you first for any closing thoughts.
But I'll say a prayer after we're done if Jordan wants to go first.
Okay. Jordan, did you have anything to add?
He's on mute.
Yeah, he's on mute. Give him another minute. Okay, Jack, I'll pass it to you. Do you have?
Okay, one last word. One of the questions was, how long has Jordan's hereditary name been in use? And I'd said 232 years, because that's not how long it's been in use. That's how long we have records written in English about it being in use. Of course, it was in use long before that. We just don't have records of it. Since 1790.
Wow, thanks for that. I missed that one in there. Thank you.
Yeah.
Okay, Archie, I'll pass it to you to close. And again, thanks for listening, everyone.
On behalf of our Tai Hawit Tlakoskam, we thank you for coming to sit with us, to hear us, to listen to us, and to support, you know, what we're doing. We thank Jack and his legal team, and we thank the Sierra Club, and we thank those First Nations who are on, wherever you're from. You're from a beautiful land. Look after it, and that we thank the non-Aboriginals that you know, we all want to see change. Believe us, we are not against access. We are against how it's done, how we get left with a mess. And, you know, every time somebody comes to access, and then the money and the companies leave, and we're stuck with the cleanup. That's not right. You know, we need change. And to always remember that Nuchatlaht's hereditary system. We have our Tai Hawit. We've always had a Tai Hawit. We have lots of Hakum. We have lots of Queens, because they're related to everybody. So I just want to thank you guys for taking the time. I know it's hot. I want you guys to go jump in the lake, cool off, and have a good evening. We'll be praying for you all tonight.
Thank you, Archie. Thank you all for coming tonight.